This just in, the Uganda Law Society and the lawyers of Kizza Besigyes have just filed an application for a writ of habeas corpus. Well, in this edition of Legal News, they are more discussing with things concerning what a writ of habeas corpus is, why they are asking for Kizza Besigyes to be brought in court, and most importantly, what is the legal impact of this moving forward because of the case of Attorney General versus Besigye. So, let's get into Legal News Daily and let's discuss all of this moving forward. Hello everyone, welcome back to Legal News Daily. I'm usual host Terry Kahuma on this channel, and straight to the point, we find that Dr. Kizza Besigyes' lawyers, Elias Lukwago and Martha Karua, in conjunction with Uganda Law Society, have filed an application for a writ of habeas corpus. Now, I've talked about writ of habeas corpus before, and this is basically bring the person to court. Habeas corpus is a Latin word meaning bring the person to court. Now, Dr. Kizza Besigyes' situation has been quite appalling. It's sad in so many Ugandans that one of the biggest freedom fighters in Ugandan history is now being subjected to a very poor health condition in prison. Now, we find that a writ of habeas corpus should be filed in form of an application. Now, Uganda Law Society and Elias Lukwago with Martha Karua have filed a writ of habeas corpus to bring Besigye to court because of his medical conditions. Now, they're doing this with what is called a notice of motion. And a notice of motion is basically a situation where you are asking court with a connection of an application to a right of habeas corpus to bring Besigye to court and then ask for his release, because according to the case of Attorney General versus Besigye, where the recent Supreme Court decision said that it is legal to try civilians in the court martial and therefore they should be released. This means that Dr. Kizza Besigye's trial in the Court of Appeal or his continuous incarceration and imprisonment in Luzira prison is now making his condition worse and worse and worse. Then we also have it in accordance with Objective 20 of the Constitution, which basically says that the government of Uganda should be able to take the priority of every citizen at the greatest priority. So basically meaning that every medical situation of any person should be taken at the greatest priority, meaning that Dr. Kizza Besigyes, being a civilian of the Republic of Uganda, his health condition is deteriorating because of the poor conditions in prison and the immense and great stress that this case has been put on him of the legal position of firearms. So that means that Dr. Kizza Besigyes should now be brought to court. That means that Justice Karekona, who this application of writ of habeas corpus was filed under, denied this application because said that this matter should not be heard expeditially. Expeditially means that it should not be heard in a very rushed way. It should not be heard critically or should not be given priority. However, we all know that it's a known legal fact that any application for a writ of habeas corpus should be heard expeditially, meaning should be given priority. Well, we also look at the fact that in accordance with Article 23, this is denying Besigye his right to personal liberty, and because this is a fundamental